A shipping company owes you millions, and their primary asset is about to leave port. If that vessel slips its moorings and reaches the safety of open water, you have a serious problem. Because once a ship hits international waters, attempting to track down the shadowy shell corporation that actually owns it is practically impossible. So you use a legal workaround. You do not sue the owner. You sue the metal itself. In maritime law, this is called an action in rem, a legal maneuver that treats the physical vessel as the primary responsible defendant in your lawsuit. To execute this maneuver in India, plaintiffs generally file their suits in the Bombay High Court, which offers some of the widest jurisdictional reach in the country. The Calcutta High Court is the other main venue utilized by maritime lawyers to secure these powerful arrest warrants before a ship can escape. By legally categorizing a multi-million-dollar asset as a person, you create a practical mechanism to trap the debt right there at the dock. But judges do not freeze international commerce lightly. Obtaining a same-day arrest warrant requires flawlessly passing a strict two-part legal test. This checklist requires direct maritime claims, cargo damage, collisions, unpaid mortgages, or crew wages. Next is Check 2, the Section 5 ownership rule. The exact company that owned the ship when the claim arose must own it today. If sold yesterday, your claim is dead. Standard maritime claims rely entirely on this unbroken chain of title. That makes verifying corporate ownership the most critical phase of preparing your case. There is one notable exception to the ownership rule, Section 9, a legal mechanism known as a maritime lien. A lien is a special classification reserved for the most severe debts, such as abandoning a crew without wages or stiffing the team that performed an emergency salvage operation. Because of these severe debts, a lien legally attaches to the ship itself. Even if sold yesterday, the liability travels with the steel. With the legal theory locked, the physical execution begins. The plaintiff files their plaint and an affidavit, double-checking that no other creditors have filed a caveat to block the arrest. In these specific maritime matters, the Indian judicial system moves incredibly fast, with courts routinely granting the order on the exact same day the paperwork is filed. Then comes the actual takedown. A court-martial physically boards the vessel, serves the order directly to the master, and notifies port customs. The warrant legally paralyzes the vessel. It cannot leave the port, immediately shifting all negotiating leverage away from the owner and entirely to the plaintiff. Once a ship is detained, the owner cannot talk their way out of it. Courts have ruled that a verbal promise or a written pledge not to sail is legally insufficient. To secure the vessel's release, they must provide immediate, tangible financial security. This usually means posting a massive bank guarantee or a specialized protection and indemnity letter. However, the law provides a severe guardrail to ensure plaintiffs don't abuse this massive leverage, Section 11. This section covers wrongful arrests. If a plaintiff rushes the checklist, misses a critical detail, and the court eventually rules the initial arrest was invalid, the financial consequences flip. The plaintiff becomes legally liable for paying all of the operational losses and damages the owner suffered while their ship was wrongly detained at the dock. Arresting a vessel is a blazing fast way to secure leverage and force a settlement. But because the underlying trial can drag on for years, it remains a high-reward, high-risk maneuver that demands absolute precision.